This Nonprofit Basics episode is the second of a three-part series on election year activities for public charities and private foundations. In Part 1, we address the prohibition on intervention in candidate campaigns for elected office. This Part 2 focuses on legislative lobbying activities by public charities. This discussion will address permitted educational and advocacy activities, the definition of lobbying, and the two different rules that apply to public charity legislative lobbying under the subjective test of Section 501c3 or the elective test for charities that make the 501h election, which allows for an objective limitation on lobbying expenditures. Then in the final part of this series, I'll address allowed private foundation approaches to advocacy. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Professionals working in the nonprofit space know that Internal Revenue Code Section 501c3 has some key language that limits their lobbying activities. The relevant part of the statute says an organization is described in 501c3 only if, among other things, no substantial part of the activities of the organization is carrying on propaganda or otherwise attempting to influence legislation, except as otherwise provided in subsection H. That's a quote from the statute. I'm going to parse through that language in this episode to help you understand what activities are and what aren't limited by this language. Before we get into the meat of the lobbying rules for public charities, remember that private foundations are subject to much more stringent expenditure rules that effectively prohibit them from earmarking their grants to public charities for lobbying activities. After we go through the definitions and the rules applicable to public charities, which provide important context for private foundation rules, I'll circle back to private foundations and remind you to take into account the next episode, which will include planning guidance for foundation funders. So here we go on our deep dive into advising clients on lobbying by 501c3 public charities. The first question to ask when diving into this topic is whether the organization has made, or should make the 501h election. Certain organizations are not eligible to make the 501h election. That includes churches and their affiliates, certain governmental units, a narrow category of organizations described in Internal Revenue Code 509A4, and supporting organizations that support organizations that are described in 501c4, C5, and C6. And as noted above, private foundations also are not allowed to make the 501h election. So for organizations that are permitted to make the election, the decision of whether to make it or not isn't always easy. Keep in mind that if the election is not made, the organization will be subject to the subjective and vague test of the statutory language in 501c3. That is, no substantial part of its activities may be legislative lobbying. There are no bright lines for what is substantial under this test, and the IRS and courts may consider all activities, volunteer time, impact, relative expenditures, in assessing whether the activities were substantial. While there is case law that suggests that less than 5% of expenditures is not treated as substantial for these purposes, it is a very vague standard. Note also that the annual IRS Form 990, which is filed by a public charity, asks detailed questions about the activities of an organization that has not made the 501h election, while the corollary reporting for an electing public charity focuses only on the actual expenditures by the organization. On the other hand, if we're thinking of the pros and cons for electing under 501h, the electing charity has an absolute cap on its expenditures. I'll cover the amount of that cap in a little bit. So a very large non-electing charity with annual expenditures over $20 million may be able to spend significantly more on legislative lobbying than the allowable cap that would apply if they made the election. This is an especially important consideration for charities with affiliates, where all of the affiliates are subject to one cap under the 501h election. A public charity makes the 501h election once, either at the time it files its application for recognition of exempt status or at any later time by filing IRS Form 5768. That election remains in effect until the organization revokes it. Once the election is made, the electing organization needs to track its lobbying expenditures so that it can report whether the expenditures have exceeded the lobbying non-taxable amount for the year. The non-taxable amount, more easily referred to as the allowable expenses for lobbying, is based on a sliding scale depending on the amount of exempt purpose expenditures in a year. The allowable amount is 20% for organizations with exempt purpose expenses up to $500,000 in that year. Then the percentage ratchets down to 15% for organizations with annual exempt purpose expenditures between $500,000 and $1 million, 10% for those spending between $1 and $1.5 million, and then down to 5% for organizations with exempt purpose expenditures exceeding $1.5 million, but only up to an absolute cap of $1 million in legislative lobbying expenses for the year. There's an important caveat to these limits, though, to keep in mind. The allowable amount for grassroots lobbying is only 25% of the amounts just described. For those of you who want more information on accounting for exempt purpose expenditures, direct lobbying, and grassroots lobbying expenses, I've put some helpful links in the show notes. The details of that are too much to cover in a podcast. Understanding the lobbying rules also requires some work on the defined terms for legislation, administrative actions, direct and grassroots lobbying, the meaning of a call to action, and the meaning of advocacy communications, since all of these terms are relevant to classifying the organization's expenditures under the 501h election. So, starting with the term legislation, what does that include, and what doesn't it include? Well, legislation includes any written proposal for a law that is proposed for approval by a legislative body, which is comprised of elected persons, with a caveat for ballot initiatives that I'll get to in a minute. The draft statutory language does not need to have been introduced as a bill in order to constitute legislation for these definitional purposes. And as I noted, legislation also includes ballot initiatives. For the latter, the legislative body is the public, and the members of the public are treated as the legislators for purposes of expenditure analysis. So for legislation introduced to a legislative body, keep in mind that legislation includes things like treaties with foreign countries, actions to approve appointment of judicial nominees, non-binding resolutions of the legislative body, and it also, the term includes foreign laws, not just domestic, federal, and state legislation. So let's back up a minute. What does legislation not include? There's a lot of different areas where public policy is advanced through actions that are not treated as legislation for purposes of these limits. Administrative actions proposed to be taken by an administrative body that is comprised of appointed officials rather than elected members is not legislation. So, for example, regulations that will be adopted by an agency of the local, state, or federal administrative branch is not legislation for these purposes. Think about FDA, IRS, OSHA regulations as examples at the federal level, state environmental agency regulations, local county land use regulations. None of these are legislative bodies, and so the actions are not lobbying for purposes of these rules. So, expenditures by a public charity to influence the administrative body are not counted for purposes of the lobbying limitations. Some other examples would include adding or removing an animal from a list of endangered species, conversations with agency staff on regulations, efforts to influence an agency report that would be used to support some policy, participation in proceedings to establish water quality objectives. All of these are examples of administrative activities that are not subject to any limitation under federal tax law. Some states do require reporting by organizations that are engaged in these kinds of administrative lobbying activities, but those rules don't affect the organization's tax-exempt status. I'll include in the show notes a few links to information about some state administrative lobbying limitations for those of you who are interested in that. So then there are some other policy-oriented activities that also are not considered legislative lobbying. These include participation in the legal process, such as lawsuits to enforce compliance with existing laws, and nonpartisan analysis, study, and research. So, returning to our focus on actual lobbying expenditures that are described in the 501H rules for an electing charity, the next track we need to go down is distinguishing between direct and grassroots lobbying. Direct lobbying means a communication directed to a legislator that refers to specific legislation and that reflects a view on that legislation. An important note here is that in the case of a ballot initiative, direct lobbying includes the communications with the public, since the people are the legislators for ballot initiatives. Grassroots lobbying, on the other hand, is an important subset of lobbying expenditures because these expenses are much more limited under the 501H election. The maximum cap for expenditures for grassroots lobbying is only 25% of the overall lobbying non-taxable amount, and not more than an aggregate cap of $250,000 in any particular year. So the distinction between direct lobbying and grassroots lobbying is important. Grassroots lobbying expenditure refers to expenses that mention specific legislation, reflect a view on that legislation, and encourage the recipient of the message to contact their legislator with a message encouraging the legislator to vote for or against the legislation. So, in other words, it's expenses out to the grassroots, the public, to contact their congressperson or senator or whoever it is that's voting on the specific legislation and encourage action. Some communications walk right up to that line and are considered advocacy communications not subject to the grassroots limits, so long as they do not include the call to action, that is, the phrasing, contact your legislator. So that's the landscape for organizations that want to lobby and stay within the lines. A quick word here. What happens if an organization exceeds its lobbying limits, either under the substantial part test or the 501H election? For an organization that doesn't make the 501H election, the consequences of substantial lobbying activity can be disastrous. The IRS's only remedy is to revoke the exempt status of the organization altogether. That's a pretty powerful disincentive to the organization that wants to exceed 5% of its expenditures on lobbying in a particular year. On the other hand, the organization that makes the 501H election is subject to a penalty excise tax of 25% on the excess amount of lobbying expenditures. Only if the electing charity exceeds 150% of the lobbying limits over a 4-year period will it lose its status as an exempt organization described in 501c3. So you can see there's a lot of room for foot faults or excessive spending if the organization has made the 501H election. Listeners who would like to hear more on the topic of election year activities for nonprofits can find links in the show notes to our webinars on the topic, as well as links to IRS materials and other resources to help navigate these waters. That's all for this episode. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Varela, Braun, and Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.